Good morning to all. Vanakkam. Lex Webinar Series was started in April 2020 when the lockdown was clamped. It was originally meant to be a platform for learning process through online media. We are happy to note that Lex Webinar Series has come to stay, gain momentum, and has become a virtual platform for continuous learning process thanks to the renowned resource persons and the valuable beloved participants. In the brief yet proud march of the webinar series, today is the 75th session. On this joyous occasion, we are happy and privileged to have Honorable Mr. Justice V. Ramasubramanian, Judge Supreme Court of India, to deliberate on a very important topic. Article 21 is one of the trinity of the indefeatable and indispensable fundamental rights. Indian Constitution is one of the lengthiest charters in the world, and Article 21 per contra is the shortest provision in the Indian Constitution. There is a famous adage in Tamil, Murthy Sirudandralum Kirti Perude, and Article 21 is a befitting example for this said adage. Like the universe, which is expanding every second, the scope and ambit of protection of personal liberty and right, Article 21 envisaged, is expanding every day. So, a towering personality is amongst us today to dwell into the interplay between euthanasia and right to live under Article 21. We, from the Lex Webinar Series, welcome Honorable Mr. Justice V. Ramasubramanian, the dignitaries and participants who are present in large number today. May I now request Honorable Justice to deliver the keynote address of the day with his blessings and patronage. Sir, you are welcome. The forum is yours, sir.
Thank you, Mr. Srinivas Raghavan. Yeah, very good morning to all of you. In fact, I must honestly confess that I ducked several invites in the past about 5 months for delivering lectures and webinars for two most important reasons. The first was that for a speaker, it is really boring to speak in front of a machine without getting any kind of reaction from an audience who will have the advantage of muting, unmuting, and commuting. The second reason why I was hesitant to accept invitations for webinars is that according to me, webinars are like chakravyuhas. And if the speakers happen to be Abhimanyus, they would know how to get in, but they would not know how to get out. But at last, the organizers of this Lex Webinar Series, like the mythological Bhagirath who brought Ganges to the earth, have succeeded in getting me here to the 75th webinar of this series. The topic that we have chosen for today's discussion is euthanasia and the right to life, interplay of Article 21. While a right not to be deprived of life and personal liberty is guaranteed to every person by the Constitution, nothing can guarantee any protection from death. Death has always been seen as a problem by many and a solution by a few. Steve Jobs said, I quote, "No one wants to die. Even people who want to go to heaven do not want to die to get there. And yet, death is the destination that we all share. No one has ever escaped it, and that is how it should be, because death is very likely the single best invention of life. It is life's change agent. It clears out the old to make way for the new." I unquote. This is what Steve Jobs said. Haruki Murakami, the Japanese writer, said something very interesting about death. He said, death is not the opposite of life, but a part of it. Thiruvalluvar said, உறங்குவது போலும் சாக்காடு, உறங்கி விழிப்பது போலும் பிறப்பு. Many religions of the world have seen death as liberation, but almost all the religions have condemned suicide as sinful. Some religions think that a man has no right to take away the gift of life granted by God. Some religions, which believe in the theory of karma, consider that one has no right to put an end to his life before enjoying or suffering all the fruits of the good and bad deeds of the previous life. But mythology is full of stories of persons who, under tremendous pressure or depression, have attempted to commit suicides. Even Sita, whom we worship as Mata, was no exception. But we must understand that euthanasia stands on a different footing than suicide, though the ultimate result of both is to put an end to human life. If you visit the website of the National Crime Records Bureau, there is a document titled Age and Gender-Wise Distribution of Suicides during 2019, cause-wise. This report identifies as many as 18 causes for suicides. These 18 causes are bankruptcy or indebtedness, marriage-related issues, failure in exams, impotency or infertility, family problems, illness, death of a dear one, drug or alcohol addiction, fall in social reputation, ideological reasons or hero worship, love affairs, poverty, unemployment, property disputes, suspected illicit relationships, illegitimate pregnancy, physical abuse, and professional or career problems. These are the 18 causes identified for suicide by the National Crime Records Bureau. But interestingly, the number of suicides that had taken place during 2019 in India was 139,123, out of which illness contributed only to 23,830 deaths. Out of these 23,830 suicides, for which the cause was illnesses, 11,009 were due to mental illnesses and 10,496 were due to prolonged illness. This information is of significance since euthanasia is directly linked to the unnatural termination of the life of a person suffering from a serious illness. All of you know that Section 309 IPC makes it a punishable offense to attempt to commit suicide and the doing of an act towards its commission. In P. Rathinam versus Union of India, the Supreme Court struck down Section 309 as unconstitutional on the ground that Article 21 has enough positive content in it to also include the right to die, which inevitably leads to the right to commit suicide. However, the decision in P. Ratnam was overruled by a constitution bench in Gyan Kaur versus State of Punjab. The court held in Gyan Kaur that Article 21 is a provision guaranteeing protection of life and personal liberty, and that by no stretch of imagination can extinction of life be read to include protection of life. Right to life is a natural right embodied in Article 21, but suicide is an unnatural termination or extinction of life, and therefore incompatible and inconsistent with the concept of right to life. The court said in Gyan Kaur that a question may arise in the context of a dying man who is terminally ill or in a persistent vegetative state, that he may be permitted to terminate it by a premature extinction of his life in those circumstances. This category of cases may fall within the ambit of the right to die with dignity as a part of the right to life, right to live with dignity, when death due to termination of natural life is certain and imminent, and the process of natural death has already commenced. These are not cases of extinguishment of life, but only of accelerating the conclusion of the process of natural death, which has already commenced. The debate, even in such cases, to permit physician-assisted termination of life is inconclusive. It is sufficient to reiterate that the argument to support the view of permitting termination of life in such cases to reduce the period of suffering during the process of certain natural death is not available to interpret Article 21 to include therein the right to curtail the natural span of life. As a matter of fact, in 1971, the Law Commission, in its 42nd report, recommended the repeal of Section 309 IPC. The IPC Amendment Bill 1978 was even passed by Rajya Sabha, but before it could be passed by the Lok Sabha, the Parliament was dissolved and the bill lapsed. However, the 156th report of the Law Commission advocated the retention of Section 309 in the statute book. But in 2008, the Law Commission, in its 210th report, said that an attempt to suicide needed medical and psychiatric care and not punishment. In March 2011, the Supreme Court too recommended to Parliament that it should consider the feasibility of deleting that section. In 2014, replying to a question in Rajya Sabha, the then Minister of State for Home said that the government had decided to drop Section 309 from IPC after 18 states and 4 union territories backed the recommendation of the Law Commission. The matter did not, however, reach its logical conclusion. In 2017, the Parliament enacted the Mental Health Care Act 2017, repealing the Mental Health Act. Section 115(1) of the Mental Health Care Act says, notwithstanding anything contained in Section 309 of IPC, any person who attempts to commit suicide shall be presumed, unless proved otherwise, to have severe stress and shall not be tried and punished under the code. Thus, a statutory presumption was raised in favor of the person attempting to commit suicide, and his trial and punishment were barred by law, though Section 309 was not repealed. Therefore, in 2018, Justice Chandrachud held as part of the Constitution bench in common cause that the observations in Gyan Cow to the effect that the right to life does not include the right to die in the context of suicide needed to be revisited. Therefore, the debate still continues in the context of Article 21. But as I mentioned at the beginning, euthanasia stands on a different footing. Oxford Dictionary defines euthanasia as the painless killing of a patient suffering from an incurable and painful disease or in an irreversible coma. In common parlance, euthanasia can be of three different types. Number one, voluntary euthanasia, where on account of intolerable pain or serious illness, the patient makes a request. Number two, non-voluntary euthanasia, where the person concerned is not in a position to take a decision. And number three, involuntary euthanasia, where the person concerned is capable of making a request but has not done so. In other words, voluntary euthanasia, non-voluntary euthanasia, and involuntary euthanasia were understood to be the three different kinds of euthanasia in common parlance. But in legal parlance, euthanasia is of two different types, namely active euthanasia and passive euthanasia. Active euthanasia is one where death is caused by the administration of a lethal injection or drugs. Active euthanasia includes physician-assisted suicide, where the injection or drugs are supplied by the physician, but the act of administration is undertaken by the patient himself. Active euthanasia is not permissible in most countries. The jurisdictions in which it is permissible are Canada, the Netherlands, Switzerland, and the states of Colorado, Vermont, Montana, California, Oregon, and Washington, D.C. in the United States, all of which legalize assisted suicide. Passive euthanasia occurs when medical practitioners do not provide life-sustaining treatment, that is, treatment necessary to keep a patient alive. Alternatively, the doctors remove patients from life-sustaining treatment. This could include the disconnection of life support machines or feeding tubes, or not carrying out life-saving operations or providing life-extending drugs. In such cases, the omission by the medical practitioner is not treated as the cause of death. Instead, the patient is understood to have died because of its underlying condition. If you have a look at the history of euthanasia, you will find that an organized movement for the legalization of euthanasia commenced in England in 1935 when Killick Millard founded the Voluntary Euthanasia Legalization Society. It was later called the Euthanasia Society. The society's bill was defeated in the House of Lords in 1936 as a motion on the same subject in the House of Lords in 1950 also. In the United States, the Euthanasia Society of America was founded in 1938. The first countries to legalize euthanasia were the Netherlands in 2001 and Belgium in 2002. In 1997, Oregon became the first state in the United States of America to decriminalize physician-assisted suicide. But opponents of the controversial law, however, attempted to have it overturned. In 2009, The Supreme Court of South Korea recognized a right to die with dignity in its decision to approve a request by the family of a brain-dead woman that she be removed from life support systems. Having seen what is suicide and what is euthanasia, and having taken note of the different types of euthanasia and its historical background, let us now see some of the cases that came up before courts. As far as India is concerned, two cases are of great significance. The first is the case of Aruna Ramachandra Shenberg.
Lordship, அவங்க மைக் மியூட் ஆயிருக்கு, அன்மியூட் பண்ணுங்க. Unmute, Lordship, may kindly unmute your mic.
I have unmuted. I have unmuted.
You are, yes. Yes. Now you are.
Suddenly it appeared.
I'm sorry for the தடங்களுக்கு வருந்துகிறோம்.
Okay. So the first case was that of Aruna Ramachandra Shenberg, and the second case was that of common cause. In Aruna, a social activist by name Pinky Virani filed a petition in the name of Aruna Shenberg, seeking a direction that Aruna, who was then 60 years of age and who was in a persistent vegetative state for 37 years, should be subjected to passive euthanasia by denying food and water, our only form of life support. The court dismissed the plea on the ground that the decision to withdraw treatment, nutrition, or water must be taken by parents, spouse, or other close relatives, or in the absence of them by a next friend. The same must be approved by the High Court. In this case, the court recognized that KEM hospital staff, where Aruna was receiving treatment, was her next friend, owing to the love and care they have given her for the past 37 years. But the staff objected to the plea to withdraw life support. Therefore, the court dismissed the petition filed by Pinky Virani. However, the Supreme Court laid down in that case guidelines recognizing passive euthanasia. In the second case, namely the one filed by common cause, the Supreme Court was approached for a declaration that the fundamental right to live with dignity under Article 21 is inclusive of the right to die with dignity. The NGO sought directions for adoption of suitable procedure for executing living wills, in which a person, when in sound and good health, may record his wish that he should not be kept alive with the help of ventilators if doctors at the stage of his life opine that he cannot be kept alive without life support systems. The Supreme Court held that an individual has a right to die with dignity as a part of his or her right to life and personal liberty under Article 21. This ruling thus permits the removal of life support systems for the terminally ill or those in incurable coma. The court further permitted individuals to decide against artificial life support and recognized the need for creating a living will. This case first recognized the concept of a living will. What is a living will? A living will is actually a medical document known as Advanced Medical Directive. Black's Law Dictionary defines an advanced medical directive as a legal document explaining one's wishes about medical treatment if one becomes incompetent or unable to communicate. There are two types of advanced medical directives. The first is a living will, which is a document prescribing a person's wishes regarding the medical treatment the person would want if he was unable to share his wishes with the healthcare provider. The second document is a medical power of attorney, which is a document which allows an individual, the principal, to appoint a trusted person as agent to take healthcare decisions when the principal is not able to take such decisions. The agent appointed to deal with such cases can interpret the principal's decisions based on their mutual knowledge and understanding. In common cause, the Supreme Court issued certain guidelines with regard to advanced medical directives. These guidelines covered a range of issues such as 1. Who can execute advance directive and how? Number 2. What such advance directive should contain? Number 3. How should it be recorded and preserved? Number 4. When and by whom can it be given effect to? Number 5. What if permission is refused by the medical board? Number 6. Revocation or inapplicability of advance directives. And number 7. What should be done in cases where there is no advance directive? These are the range of issues that were taken into account by the Constitution Bench of the Supreme Court in common cause to lay down certain guidelines with regard to advanced medical directives. Now we will go to some cases from other jurisdictions which may be of interest to a student of law. I hope all lawyers and judges are also students of law. In Pretty versus England, the applicant was suffering from a motor neuron disease. As a result of the progression of the disease, severe weakness of arms and legs and muscles involved in control of breathing were affected. Her disease progressed to such an extent that she was in enormous pain and was physically unable to take her own life, even though she desired to do so. Her husband was willing to assist her, but was concerned with the repercussions. I do not know how many husbands would be concerned of their wives in such a condition. They would have been willing to assist her. In UK, suicide is not illegal, but assisting someone in committing suicide is an offense. Therefore, this lady by name Pretty sought relief from the European Commission of Human Rights on the basis that the denial by the Director of Public Prosecution of permission to her husband to assist her in committing suicide was violative of Article 2 of the European Convention. Article 2 guarantees freedom from inhuman treatment. She also relied upon Article 8 of the European Convention, which guaranteed the respect for private life. She contended that my decision to take away my life because of the enormous pain that I suffer was part of my private life, and the Director of Public Prosecution had no right to violate Article 8 of the Convention. This was her contention. As far as the first contention revolving around Article 2 was concerned, the court held that the right to life guaranteed in Article 2 of the European Convention could not possibly be interpreted to provide a negative complementary right to die. However, the European Commission held that if a state were to read Article 2 as encompassing a right to die, then that kind of a reading or interpretation would not violate the convention. The court also found that the right to determine the means and timing of death could possibly be read into the right to respect for private life. In the ultimate analysis, the European Commission held that the Director of Public Prosecution could not be held to be guilty of violation of the European Convention of European Convention. The next case that we can take note of is the one in Haas versus Switzerland. Haas was a person who suffered from bipolar disorder and he wanted to commit suicide. He attempted to obtain sodium pentobarbital. I request lawyers not to make a note of the name of the drug. Then I will be guilty. It will not be physician assisted, it will be judge assisted. He obtained this particular, he wanted to obtain this particular drug, which was available only on medical prescription. He made several applications, but the same was rejected by court. He finally approached the European Commission for Human Rights, complaining of violation of his right to respect for his private life. He argued that due to the domestic court's decisions, his right to decide the moment and manner of his death had not been respected. He maintained that in exceptional circumstances such as his, access to the necessary substances should be provided by the state. That was his argument. ECHR explained right to life under Article 2 as follows. It said, Article 2 creates for the authorities a duty to protect vulnerable persons even against actions by which they endanger their own lives. This later article obliges the national authorities to prevent an individual from taking his or her own life if the decision has not been taken freely and with full understanding of what it involved. The European Commission held that the right to life guaranteed by Article 2 obliges the state to establish a procedure capable of ensuring that a decision to end one's own life does indeed correspond to the free will of the individual concerned. The court therefore recognized that the right of an individual to decide the manner and moment at which his life should end is one of the aspects of the right to respect for private life, provided that the person in question is capable of forming his or her own free will in this regard and to act accordingly. The third case that may be of some interest is Lambert versus France. In this case, the European Commission was asked to decide whether the decision to withdraw artificial nutrition and hydration of Vincent Lambert violated right to life enshrined in Article 2. This Vincent Lambert met with a serious road traffic accident that left him tetraplegic and with permanent brain damage. He was assessed to be in a chronic vegetative state that required artificial nutrition and hydration to be administered via a gastric tube. Parents of Vincent approached the ECHR alleging that the decision to withdraw artificial nutrition and hydration breached the state's obligation under Article 2. ECHR emphasized that Article 2 imposes on the states both negative and positive obligation. The negative obligation is to refrain from intentional taking of life, and the positive obligation is to take appropriate steps to safeguard the lives of those within its jurisdiction. Therefore, the court held that the decision of the doctor to discontinue life-sustaining treatment did not involve the state's negative obligation under Article 2. The convention, it was held, must be read as a whole, and therefore, in a case where there is possible violation of Article 2, right to life, and a possible violation of right to respect for a family life under Article 8, it included the personal autonomy. Therefore, the European Council recognized the notion of personal autonomy as part of Article 8. The court noted that there was a consensus among European member states as to the paramount importance of the patient's wishes in the decision-making process. However, those wishes, however well or ill those wishes are expressed. It identified that in dealing with end-of-life situations, states have some discretion in terms of striking a balance between the protection of the patient's right to life and the protection of the right to respect their private life and their personal autonomy. The court considered that the provisions of the law on patients' rights and the end of life promulgated in France, making changes in the French Code of Public Health as interpreted by Council that constituted a legal framework which was sufficiently clear to regulate with precision the decision taken by doctors in situations such as in which Mr. Lambert was placed. While considering the state's positive obligation in this case, the European Council held that the regulatory framework developed in the Public Health Code and the decision of the Council right established several important safeguards with respect to therapeutic abstention, and the regulation is therefore apt to ensure the protection of patients' lives. Coming to England, one of the important cases to be taken note of was Airedale NHS Trust versus Bland. In this case, one Anthony Bland, a supporter of Liverpool Football Club, who had gone to Hillsborough ground, suffered severe injuries as a result of which supply to his brain was interrupted. Eventually, he suffered an irreversible damage to the brain, as a consequence of which he got into a condition of persistent vegetative state. He became incapable of voluntary movement and could feel no pain. He was not in a position to feel or communicate. To keep him alive, artificial means were taken recourse to. In such a state of affairs, the treating doctors and the parents of Bland felt that no fruitful purpose could be served by continuing the medical treatment. As there were doubts with regard to the stoppage of medical care, which may incur a criminal liability, a declaration from the British High Court was sought to resolve the doubts. The family division of the High Court granted the declaration, which was affirmed by the Court of Appeal. The matter travelled to the House of Lords. This was in 1993. In the context of existence in persistent vegetative state of no benefit to the patient, the concept of sanctity of life, which is the concern of the state, was held not to be an absolute one by the court. Lord Gough held that the principle of sanctity of life is not an absolute one, and there is no absolute rule that the patient's life must be prolonged by such treatment or care, if available, regardless of the circumstances. Lord Mustill observed that an argument had been advanced that it was in the best interest of the community at large that Anthony Bland's life should end. The doctors had done all they could have done. It was a lose-lose situation, as nothing would be gained by continuing Bland's treatment and much would be lost. The distress of Bland's family members would steadily get worse, and so would be the strain of the medical staff charged with the care of Bland, despite the fact that Bland's condition would never improve and he would never recognize that he was being cared for. Further, it was observed that large resources of the country in terms of skill, labor, and money had been applied for maintaining Bland in a present condition, which in the opinion of many could be fruitfully employed in improving the conditions of other patients who, if treated, may have useful, healthy and enjoyable life for years to come. This is how Lord Bristol reasoned. Why do you throw the national resources such as skill, labor, money, etc. upon a person who is never going to improve and come out when those resources could be usefully employed in reviving other patients? That's how Lord Bristol reasoned. The next case in England was the one related to a person called Paul Lamb. Paul Lamb was severely injured in a road traffic accident and he was paralyzed from neck down. In 2014, he approached the Supreme Court of UK challenging the UK Suicide Act, which makes assisting a suicide a criminal offence punishable with 14 years imprisonment on the basis that it is violative of Article 14, a right not to be discriminated against on the ground of disability in respect of enjoyment of the other rights in the convention. The court observed that the Parliament must be afforded an opportunity to debate the issue before the court decides whether to declare the law incompatible with its human rights. In May 2019, Paul approached the court once again stating, "I am paralyzed from the neck down. I live in a state of constant pain. In the future, my suffering will inevitably become too much to bear. When that happens, I want to be able to control and choose the circumstances of my death. As the law stands, my only option would be to die through the inhuman process of dehydration and starvation. This situation cannot be allowed to continue." 5 years ago, I am reading from what Paul Lamb wrote. 5 years ago, I asked our courts to give me the right to control my own death, and they told me to wait. Since then, I have watched and waited for 5 years as new evidence has emerged and progressive countries have given millions of others the choice I have asked for, and still the UK Parliament has done nothing. I have no option but to ask the court to intervene again. I need them to help me and many others in my position to end this cruel and discriminatory law. The court, of course, took pity on him. In so far as USA is concerned, one of the earliest cases to come up there was Curzon versus Director, Missouri Department of Health. In this case, the court dealt with the case of an auto accident victim who was in hospital for years in a persistent vegetative state from which there was no scope for recovery. According to medical opinion, the patient was utterly with no consciousness or feeling. Her parents requested that she be detached from life supporting system, citing their belief that such had been her own wish regarding her fate should she ever fall into such circumstances. But the same was refused by the hospital administrators, citing Missouri state laws requiring clear and convincing evidence in the form, example of a formally executed living will, that termination of life would accord with the patient's own wish. Curzon's parents went to court claiming that the Missouri law unjustifiably infringed a fundamental aspect of Curzon's liberty without a sufficiently weighty or compelling reason for doing so. The Supreme Court rejected this claim. The Supreme Court held that competent individuals have a right to refuse medical treatment under due process clause. But the court found that Missouri's law requiring clear and convincing evidence is constitutional, as family members might not always make decisions that the incompetent person would have agreed with, or those decisions might lead actions that would be irreversible. So the case was lost. The next case to come up there was the one in Washington versus Glucksberg. In this case, a suit was filed challenging the state of Washington's ban on physician-assisted suicide. Whether the state's ban on physician-assisted suicide violates 14th Amendment's due process clause by denying terminally ill the right to choose death over life was the question involved. The Supreme Court held that the right to assisted suicide is not a fundamental liberty interest protected by the due process clause, since its practice had been and continues to be offensive to the national tradition and the practices. The court also held that the state's ban rationally related to state's legitimate interest in protecting medical ethics, shielding disabled and terminally ill people from prejudice, which might encourage them to end their lives, and above all, preservation of human life. Though even in this case, the court turned down the request. Coming to Canada, one of the important cases that the Canadian courts had occasion to deal with was Sue Rodrigues versus British Columbia. Rodrigues was a 43-year-old woman who was diagnosed with what is called amyotrophic lateral sclerosis, ALS. Doctors told her that she would lose the ability to swallow, speak, walk, and move her body without assistance. Then they said she would also lose the capacity to breathe without respirator, eat without gastrostomy, and would eventually be confined to bed. That was the opinion given by the doctors. Doctors estimated that her life expectancy was 2 to 14 months. Therefore, Rodrigues approached the Canadian Supreme Court to allow someone to aid her in ending her life. By a majority of 5-4, her request was rejected. Justice Sopinka, speaking for the majority, laid down certain principles. She said, I quote, "Sanctity of life has been understood historically as excluding freedom of choice in self-infliction of death, and certainly in the involvement of others in carrying out that choice. At the very least, no new consensus has emerged in society opposing the right of the state to regulate the involvement of others in exercising power over individuals ending their lives." Therefore, the case was lost. In Carter versus Canada, the prohibition of assisted suicide was challenged as violative of Section 7, which guaranteed the right to life, liberty, and security of the person. It was also challenged as violative of Section 15, which guaranteed equality under the Canadian Charter of Rights and Freedoms. The Supreme Court held in this case, Carter vs. Canada, that adults who are mentally competent and who are terminally ill could take doctor's assistance in dying. The court held that Section 241B of the Criminal Code, that prohibits aiding and abetting a person to commit suicide, and Section 14 that prohibits one to consent to have death inflicted on them, unjustifiably infringe Section 7 of the Charter. The court also held that it is of no force or effect to the extent that they prohibited physician-assisted death for a competent adult person who clearly consents to the termination of life and who has a grievous and irremediable medical condition, including an illness, disease, or disability that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition. Having seen some of the interesting cases that came up before the courts in other jurisdictions, now let us see what are the challenges that lie ahead. As lawyers and judges, we do not always get cases which fit into pigeonholes. Straitjacket cases do not come to us. If at all those cases come to us, we ensure that they do not any longer be straitjacket. Sometimes the courts may be confronted with conflicting opinions and adversarial interests. This happened in one particular case in England. As we have seen some time ago, there are cases where the individuals whose consciousness is very clear and who take a conscious decision to put an end to their life, who come to court. There are cases where the close relatives like parents, spouses, and children come to court. There are also cases where very, very close relatives or next friends come to court seeking appropriate orders. But what happens in cases where the doctors come to court and their opinion conflicts with the views of the close relatives? Suppose the close relatives want the life to be terminated, but the doctors hold an opposite view. The courts will have no difficulty in accepting the view of the doctors. But take, for instance, cases where close relatives want the retention of life, but the doctors opine otherwise. What would their court do? This is the question that arose in a case about which I had an occasion to write in the Hindu about 4 years ago. On April 11, 2017, Justice Nicholas Francis of the Family Division of the High Court of England and Wales gave a ruling allowing a hospital to withdraw treatment to an 8-month-old baby. He said, I quote, he wrote a very beautiful judgment. He said, I quote, with the heaviest of hearts, but with the complete conviction that it would be in the best interest of the baby, I allow the hospital to withdraw the treatment, save palliative care, to enable that little darling to die with dignity, I unquote. This baby was born on August 4, 2016 with a condition called mitochondrial DNA depletion syndrome. It's called MDS. It is an autosomal recessive disorder whose symptoms may manifest either as myopathic or as hepatopathic or as encephalopathic. The baby had encephalopathic form of this MDS, mitochondrial DNA depletion syndrome. This form of MDS causes progressive muscle weakness and brain damage. The child was undergoing treatment at a hospital called Great Ormond Streets Hospital, GOSH. The doctors at this GOSH, where the baby was undergoing treatment, came to the unanimous conclusion that it would not be in the best interest of the child to subject it to a particular therapy called nucleoside therapy, which was offered by a doctor in the United States. The doctor in the United States claimed that he could offer this particular therapy, namely nucleoside therapy, to patients who were undergoing this particular syndrome. The parents of the baby made an emotional appeal to give the baby a chance, a window that was open, however small it was, so that they could take the baby from England to USA for treatment. From the time the doctor in the USA indicated the possibility of this nucleoside treatment, the parents of the baby were able to raise 12,67,080 British pounds through a GoFundMe web page. But the judge had the courage of conviction to reject it, since the success of such treatment was admittedly highly uncertain, as it had not even been tested on mouse models. Justice Nicholas Francis not only made the consultants at the Great Ormond Street Hospital, where the child was being treated, speak to the doctor in the USA, but the judge also recorded the evidence through teleconference. He first made the doctors at GOSH talk to the doctor in the USA through video conferencing. Thereafter, he recorded his evidence in teleconference. The United States doctor confirmed during his interaction that he had never treated anyone earlier who had encephalopathy with nucleoside therapy, and that therefore he could not provide any scientific evidence to show that a patient with such a syndrome would respond positively to the treatment. In other words, he confessed that the patient and its parents will have to take a chance. After a great deal of discussion with the experts in the field, the judge of the family division of the UK High Court found that there is no evidence to show that nucleoside therapy can cross the blood-brain barrier, which it must do to treat what is called RRM2B gene. This is actually called ribonucleoside diphosphate reductase subunit M2B. That the abbreviation is called RRM2B gene. This is an enzyme that is encoded in humans. The judge was convinced that exposing the child to a nucleoside therapy may perhaps benefit medical science on account of its possible outcome, but ruled that such experimentation will not be in the best interest of the child unless there was a prospect of benefit for the child. Look at the reasoning given by the judge. He said, if you want to administer a therapy to a patient which has not been tested even on mouse models, your application of the therapy may benefit medical science eventually, but it is not of use to a small 8-month-old baby. Tossed between a dispassionate medical opinion rendered by experts in the field and a very, very emotional, passionate appeal made by the parents of the child to allow them to go to America, the judge answered a question that would normally surface in the mind of a common man. In fact, when I wrote this article in the Hindu, many people asked me, sir, why should the judge take a call? After all, the baby is 8-month-old. The parents are willing to take a chance. They want to take the baby to America for treatment. Why should the court stand in the way? What is your role there? What is your role as the judge? Was a question that many people asked me. This question probably was asked by the judge himself, and he answered this question as follows, I quote, "Some people may ask why the court has any function in this process. Why can the parents not make this decision on their own? The answer is that although the parents have parental responsibility, overriding control is vested in the court, exercising its independent and objective judgment in the child's best interest. Unquote. Pointing out that the intellectual milestone for a judge in a case of this nature was to find out what is in the child's best interest, and that the judge must look at the question from the assumed point of view of the child. The judge agreed that there is a strong presumption in favor of a course of action which will prolong life, but such a presumption is a rebuttable presumption. The judge wrote, finding that a child of tender age was actually lying in bed, unable to move, fed through a tube, breathing through a machine, and uncertain to recover from the nucleoside therapy, the judge eventually came to the conclusion that the doctors should be permitted to remove the life support system and give only palliative care and allow the child to die with dignity. The judge concluded his opinion with a tribute to the parents of the baby for their absolute dedication to their wonderful boy from the day he was born, and also their brave and dignified campaign on his behalf. The beauty of this judgment is that it is apparently filled with emotions, but nonetheless was a product of a strong intellect. You may fill the entire judgment with all your emotions, but ultimately the conclusion should be a product of your intellect. This judgment was an indication of that. This judgment assumes significance in the wake of the fact that there is no law in the United Kingdom which sanctions the right to die with dignity. This is in contrast to the United States of America, where the states of California and Colorado have statutes known as End of Life Options Act 2016. The state of Oregon has an act known as Death with Dignity Act 1997. The state of Vermont has an act called Patient Choice and Control at the End of Life Act 2013. And Washington has an act called Death with Dignity Act 2008. But what distinguishes most of the cases that arise under those statutes in USA from the case which I discussed right now was that the court had to make a choice in this case contrary to the wishes of a small baby, contrary to the wishes of the biological parents of a very small baby. Therefore, it is not always very easy to make this choice. In fact, I remember that when I was a child growing in my native village, I used to hear suddenly at times what is called adirvetu, huge sound. My mother used to tell me that probably somebody will die. I used to wonder, and whenever I asked my mother, she used to tell me that whenever a very old person for whom no medical treatment will be of any avail, or for whom no medical treatment could be given, if the life is getting prolonged, they will do what they will fire what is called as adirvetu, and he will die of a heart attack. This is probably the crudest or the most prevailing form of euthanasia that was adopted in villages for a long time to come. In fact, when I told one of my friends that I was going to talk in a webinar on this subject, he made an interesting observation between active and passive euthanasia. He said, if you are a speaker in a webinar, you are guilty of active euthanasia, and if you are a listener in a webinar, you are guilty of passive euthanasia. Dear friends, to conclude, I would only say that in a country like India, the challenges are one too many. Poverty, affordability of treatment, lack of resources for the immediate family to take care of the ill, lack of public resources, all these things complicate matters most. Therefore, in many cases, people resign themselves to fate, and even the choice of prolonging life with costly medication is not available to millions of people in a country like India. Therefore, to some extent, I can say this academic discussion may probably lay the foundation for future when everything is bright and the affordability, either the affordability of the individuals or the affordability of the state to provide health care to all concerned increases. With these few words, I thank the organizers for this wonderful opportunity. Thank you very much.
Thank you very much, Lordship. The Bhagirath Prayatnam we had to bring the Ganges from Delhi to Madurai via Chennai virtually has proved to be very successful. And I'm sure that the thirsty horses were totally quenched by the deliberation Lordship was able to make. And the deliberation was so minute that an international scenario has been totally brought into the fora, and the native practice of what is called an cruel way of active euthanasia is also touched upon. And a typical mark of your Lordship's a tinge of humor is always there, spruced up everywhere, and it made the session thoroughly enjoyable. In the words of former sage of India, Honorable Mr. Justice N.M. Venkatachalaya, life is not mere subsistence, but one with dignity. Freedom and personal liberty occupy the highest place in the constitutional scale of values. I fondly remember the minority voice of Honorable Justice Fasal Ali in the famous A.K. Gopalan's case that was delivered in the formative years of the March of Constitutional Law. He said that any interpretation that would deny the sweep of due process to Article 21 would result in the most important fundamental right to life and personal liberty being left at the mercy of legislative majority. We wholeheartedly thank your Lordship for the exuberant and erudite session with an unfathomable amount of gratitude, and the deep and insightful session echoes the thought process of your Lordship that a debate may be opened or a constitutional solution may be found if such kind of academic exercises are being taken out. And we thank the patrons of the webinar series that includes honorable judges of the Madras High Court and judges of other high courts, senior advocates both in the Madras High Court and Supreme Court, and leading counsels across the country who have contributed by their nutritious food to the child of the webinar series from his conception and continuing in his infancy. We have a YouTube channel with 5,510 members and viewership of more than 180,000 viewership. That makes the webinar special because of the patronage and the support of resource persons like your Lordship. And we thank your Lordship and all the participants once again. We request your Lordship to accept our thanks and bless us, because we only share the knowledge like the moon reflecting the ever-glowing light of the sun. We seek your blessings, your Lordship, and we thank you so much. Thank you. May I sign off, my Lord?
Yes. Okay. Thank you.
Thank you.